Ahmed will start at 6:05 because people are joining even now. So just 4 more minutes. Is that okay? Is that okay, ma'am?
Okay, I think you can just
Yes,
begin.
yes.
I think we're able to start the session now. So Ahmed, you may start the session.
Yes, we
Okay.
can. It's,
Um,
yes.
oh, can I start? Ladies and gentlemen, distinguished guests, and the fellow advocate for justice. My name is Ahmad. I'm from Nigeria, you can see, and I'm currently a master's student, masters of law student at the Universitas Erlangga in Indonesia, particularly in international law. It is with great pleasure and profound honor that I welcome you to this momentous session, the paramount topic of the right to freedom from discrimination. Um, in a world where diversity is our greatest strength, it is essential that we gather here today to shed light on this fundamental human right. and we are shedding light on it in order to explore its significance and to ignite the flame of, change, you know, that will eradicate discrimination from all over the world in our respective societies. So discrimination in all its forms is an affront to very essence of humanity, as we all know, because although we all know that discrimination is something that is not absolute, of course there can be some kind of uh, distinction, but not all distinctions are actually arbitrary. And basically, arbitrary discrimination stifles progress and corrodes social harmony and diminishes the vibrant tapestry of our shared existence. So, whether it is based on race, gender, religion, or whatever it is we may call it, discrimination is an injustice that we believe it should never, of course, be tolerated. So today, basically, we have the immense privilege of hearing from a true champion and an esteemed expert in this field. Our esteemed speaker, Ms. Bali, has dedicated her life to advocate for right of freedom of discrimination, because I read some of her article, and has been instrumental in shaping, maybe, probably, we don't know, maybe policies and fostering inclusive communities. So permit me please to introduce the speaker.
Thank you very much for introducing, for the nice introduction and the overall perspective about the conference that you have given. Today I take this opportunity to discuss about right against discrimination in contemporary times and from a human rights perspective. So, from our very constitution, if you see, from the drafting of a constitution, the endeavor of our legislators was to ensure that every point the protected class was brought in the purview of protection against being discriminated. Discriminated would mean that um, they're not they do not face any action which is very arbitrary or random in its nature, but now through its constitutional evolution of that concept we have affirmative action as well, which provides an emphasis on the governments to take some action to protect, to provide rights to those protected class of the society. Protected class would mean uh, gender, sex. It would mean religion, race, caste, sex, place of birth, or any of them. They should not be discriminated on these grounds, and it has been provided under Article 15 of Indian Constitution. And I think this has to be read with Article 14 of Indian Constitution, which provides for freedom of speech and expression. 1 minute. Protection of life. It has interconnection with other provisions of the constitution, such as right to protection of life and liberty under Article 14, and freedom of speech and expression under Article 19, and 21 as well, which concerns liberty. And if we see in the recent times, the current government in India, they have been trying to sabotage these rights, but performing such policies minorities, especially when, if you see in Karnataka, there was a hijab ban which was brought in place. It is not any part of any educational policy that you will have to have a common uniformity in how you dress, or how you present yourself in a class. So that is one of the random policies that was brought in place by the government. Okay, so and another thing we could take an example of beef ban. Beef ban would mean that you're affecting the right to make a choice, dietary requirement. You're trying to sabotage somebody's right to make some choice with respect to what they want to eat. So that is again violation of um, Article 15 and Article 21 as well, because you're affecting the right to take decisions with respect to their life and health. Um, and I would also want to ask a few questions about it. What do you think with respect to empowerment of the marginalized section in our education institution? With the recent amendments to the policies, they're removing chapters, historical chapters, which were very relevant to for the enlightenment of the students. What do you think about it? I have a
You
question.
said
I'm
anybody, anybody like people. Sorry, please. People are just joining. Marginalized. Okay, basically, I
You
think
can
let
also
me just answer that part. Anything that has to do with marginalizing people, I think it's more of a structural discrimination, isn't it? And that is, of course, if it is, it depends on what kind of marginalization you're talking about. Is it maybe stereotyping some people or profiling some people? So if people are marginalized, it's also a form of discrimination.
yes, profiling, then identifying. When you identify and profile certain section of society, that is, and you take action, specific actions targeted at them, then that would be an arbitrary or randomness. The action would be the administrative action of the state would be very random. And I think so when you review, these actions should be reviewed by the judicial institution, and our courts should protect and uplift the spirit of our constitution, and should be free from any political bias, and that with very respective. So what is happening, if you see also now that the case, the LGBT case that is happening, which is up for hearing in the Supreme Court, the the arbitrary nature of definition of what constitutes a family, what constitutes a marriage, given by the council representing the government, that is also very narrow. It's very defined in a very narrow manner, and it reflects outdated customs and traditions, beliefs, which tends to further provides marginalized the LGBT section in our society. But thankfully, we have a very progressive and outward-looking constitutional bench which is hearing this case. And I think, but as of now, the judgment is reserved. I think they should have gone beyond just reserving the judgment and provided the non strict guidelines for non-discrimination for LGBT couples who could uh, easily adopt or easily get into wedlock, wedlock ceremonies, enter into marriage, or basic, or maybe adopt if they wanted. But right now they have to face so many numerous restrictions and so many bureaucratic procedures that themselves formalistically they face so many prejudices. And as such, because of this, reflecting this, the society's mindset is still um, not very inclusive, not very they still are not able to accept the fact that there is something, uh, that there's another third gender, that an individual can make an informed decision on the basis of how, their ability to consent or ability to take information. So that's how the society has become very very exclusive, with especially since the time we have this the government at the center. So I think because of that, it is we have facing a lot of challenges. And if you also see, we have the removal of Article 370 uh, was also very random. If you see, because um, the legislative consent from the state's legislature was also not taken. It was This whole process was taken at the central level in 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 Indian Parliament. So without taking the consent of the state, they violated again against on the ground of race and ethnicity. And but I think the grounds the grounds are not very exhaustive again in Article 15 and 14. And as you see, rule of law is the basis for forming any law or undertaking any executive action. They were not very in conjunction with each other. So that's why we are saying lack of governance in many parts of our country. The things that they call as development, the things I mean, the activities they have taken to show that they are carrying out development, they're doing it again in contravention of the rights of other sections like labor of migrants or displacements of local community. And that is also one of the examples you can see. And then there's again violation. You can see this force this time to time there is prejudice on the basis of language as well. Many people in a community in India, they're forced to speak in Hindi, like uh, especially there's an emphasis by the central government that you have to speak in you have to speak in there should be more promotion of Hindi as opposed to celebrating the cultural diversity. Again, then this is violation of the fundamental tenet of maintaining brotherhood and fraternity and promotion of cultural and linguistical diversity. So what you see, the Article 15 and 14 and other fundamental rights mentioned in uh, part 3 and 4 of our Indian Constitution are being violated both directly and indirectly. And it is time. It's very important both for the younger generation as well as those in in the government section to up to keep the spirit of the Constitution in light and broaden our understanding of how the other should how other person should exercise their own freedoms and be responsible to act on their duties as well. And I think it should be this conversation today that we're talking about, it should be a two-way. So I would want your view. What is your opinion about Indian politics at the moment? How do you think it is violating Article 14 and 15 of Indian Constitution? Is anyone of you up to talk about it?
Okay, I'm not well abreast with Indian politics. So people in the house, can you
Yes,
please
ma'am, I would
answer
like
that?
to add my point.
Yes, yes, please do.
Yes, ma'am. Like you asked, what's the stand of the government right now in politics? Right now, what I would like to say is that in the same issue of same-sex marriage, one of the reasonings stated by the government was that marriage is a sacred institution in the Indian society. Now, even now, the government focuses on the orthodox practices of which existed long back ago, rather than focusing on people's rights. And we know same-sex marriage is something which should be legalized, in my opinion, at least, as Article 21 says, right to life, and everyone has the freedom to live their life according to their choice, provided that it doesn't violate others' fundamental rights. So I believe even now the government stance is based on the societal norms that was introduced long back ago. So I think there needs to be a development from that stats.
but we have been relying on concept of rule of law of AV dicey for a long period of time, that law should not be applied unfairly, that the government should act in obedience to the law, that there should not be any retrospective application of any law. There was criminalization of LGBT rights before. Thank God, Article 377 has been decriminalized. Some development is there. Then you have equal access to the courts and administration. So these are some of the principles of rule of law that is undermining the need for reforms. That is what I'm trying to emphasize. That when we talk about equality and right against discrimination, rule of law is underpinning, is is the basis for these. But the government is making the policies completely relying on their powers, which the constitution gives them the right to make policies, to undertake in the interest of the public. The term public order has been defined so broadly that the government tries to define it from the majoritarian lens. So whenever we just define it, defines what the rights, for example, rights of a couple in a marriage should be like, it's completely derived from Indian scriptures, from customary practices, outdated ones, which give gives a rise to arbitrary understanding of uh, their application of the rights, application of their policies, I think. For example, give me a moment. For example, the rights of the journalists, like freedom to form association, to speak out, to be in groups, to be in unions. It's violating. It's whenever a journalist in Kashmir is trying to speak out against atrocities, against um, unorderly ban of information technology, or other deprivation of rights. That is also one of the examples we can see from perspective of Article 14. And we have a Human Rights Act too, and which provides, just give me a moment. No. And there is one important aspect of Article 15 that I would want to discuss today, that there is a horizontal prohibition of denial of access. Unlike Clause 1 of Article 15, which is addressed to the state, Clause 2 creates a broader prohibition on disability, liability, restriction, or condition with regard to accessing various public spaces in commercial establishments. Subclause A further uses the word shop so broadly to mean premises where goods are sold in any capacity, and including everything from hairdressing salons to educational institutions. Therefore, there cannot be shops, public restaurants, or spaces of public entertainment which are reserved on the basis of any of the protected grounds. And some scholarship also argue that the definition of shop in subclause A should also extend to all private economic market transactions, including exclusionary covenants for the lease of property. So Article 15 is also dealing with the right to property. I mean, access to commercial establishment. And further clause, subclause B also relates to the use of wells, bathing ghats, roads, places of public resort maintained wholly or partly of state funds, or dedicated to the use of general public. Accordingly, private wells and tanks are not regulated by subclause B. There is a differentiation. It is only covering the public area of access, but not private areas of access, such as private wells. So there is still this part of subclause B of Article 15 needs to be amended. unless but there is a provision to it. Unless these private wells are dedicated to the general public, um, then there's special provision that we have talked about in Article 15. Subclause 3 to 6 provide for positive discrimination. Again, I was talking about uh, affirmative action, like providing for uh, reservation of special categories such as scheduled castes, scheduled tribes, tribal groups, those belonging to underrepresented or vulnerable of sections. They're protected under affirmative action. For example, there's also, you can take about promotion of female education or prohibition on fem- female infanticide. So prohibition against female infanticide is a negative duty, which means it should not be carried out. But if you talk about reservation or providing them with job opportunities, providing with them access to economics and socio-political resources to help them exercise their right to political choices, that is an affirmative action again. But I think right to if you keep on providing with reservation also, then it leads to stagnation in economy. Then there is lack of competition, and if you see there'll be lack of competition, it become very um, the country's democratic structure becomes very slacking in nature. There is more discontent within other groups in the society. It would lead to more exclusion of that underrepresented groups and more clashes. So there should be reduction in uh, reservation, and there should be more promotion in um, being in individuals' ability to undertake they should be able to develop their rights. They should be able to know what avenues they have to redress, to get their grievances redressed constitutionally and legally. So that is one thing I would suggest, that our that citizens of a country should undertake upon, and legislatively this should be considered. And this Article 15, which was brought what 103rd Amendment to the Constitution, said it was challenged in the Supreme Court. Was challenged in the EWS reservation, Youth for Equality versus Union of India. They argued that it violates the basic structure of Indian Constitution, which in their view does not allow reservation on purely economic criteria. On furthermore, on 7th November 2022, a five-judge bench of Supreme Court of India held in Janhit Abhiyan versus Union of India that the 103rd Amendment did not violate the basic structure. Justice Maheshwari, Trivedi, and Pardiwala wrote separate judgments for the majority, while Justice Bhatt wrote a dissenting opinion on behalf of himself and Chief Justice Justice Lalit, that has been placed in progressive quarters. So the basic structure has been preserved, as well as that it has been stated that Article 15 does not violate any of these rights. It does not violate the basic structure of the Constitution. As you see, basic structure is a common law doctrine that the constitution of a sovereign state has certain, which states that the constitution of a state has certain characteristics that cannot be erased by its legislature. This doctrine was importantly recognized in Keshav Nanda Bharati versus State of Kerala, where the doctrine was formally adopted. So it has not been violated. It has been recently held. So from time to time, our country goes through constitutional turbulences that these basic rights are challenged. The same thing is happening in the U.S. as well. The fundamental right to abortion was challenged, which was brought through Roe versus Wade in the Supreme Court of United States, that is also being overturned. But still, the state courts, the various federal courts are determined to protect. There's a mixed reaction over there. Some states are upholding the fundamental rights, while some states are becoming regressive, moving backwards from the precedents. So there is a mixed reaction due to both the populism and discontent with the democratic forces, with how they run, with increasing corruption, with increased dissatisfaction with what they expect from both the judiciary and the executive, and lack of clarity in the legislation that is brought in. So all of these factors are leading to the decreasing favor for fundamental rights for the protected class. And I would want to open the table for discussion also. And if anyone wants to add some point to this, you're free to do it.
Uh, what do you, Nihal?
Guys, if anyone have you any questions or would like to add the point, please do so. Now I think you can continue. If we have any questions, they can raise their hands, and then we'll ask them accordingly.
Yes. This thing, equality, and this very essence, which is, but I'm very glad that Justice D.Y. Chandrachud has been taking particular case of not only upholding spirit of the constitution but making clear cut uh, points in his judgments that there's a need to be just give me a moment. Justice Chandrachud has also recognized that indirect discrimination would violate the fundamental right to equality under Article 14 of the Constitution, and as much as direct discrimination. So he's recognized both direct and indirect form of discrimination in his judgment in 2018. And he further went on to state that a provision such as Article 377, which is challenged as being ultra vires the prohibition of discrimination on the grounds only of sex under Article 15, subclause 1, is to be assessed not by the objects of the states in enacting it, but by the effect that the provision has on affected individuals and on the fundamental rights. So he's emphasizing both on objective as well as effects, but he's going more in favor of effect of the legislation by the effect that the provision has on affected individuals and on the fundamental rights. Further, he stated that any ground of discrimination, both direct or indirect, which is fundamental on a particular understanding of the role of the sex, would not be distinguishable from the discrimination which is prohibited by Article 15 on the grounds only of sex, as Chandrachud had stated that time. And I think to promote justice, to promote to understanding what is arbitrary and discrimination, not only emphasizing on the education, legal education from the schooling is required, but promoting empathy. Promoting empathy is also very important to address discrimination in colleges. He has recently said in an event in Hyderabad that what you see, because of the discrimination, we see various social evils like people committing suicide. They're not even being able to attain uh, a good level of education, or or discrimination on the grounds of religion. Or, for example, they're secluded from attending social events, or they're looked down. For example, the scheduled caste or tribes, they're looked down upon in the college. So he said that there's a need to there's this crucial role in making a dialogue with the society inside and outside the courtrooms to push for social change. He said that true solution lies not only in making society casteless, but in finding justice for victims of caste discrimination. He he said that at an event in IIT Delhi. Spoke. And one thing, he also said that caste system still pervades the society, and we must come to face with that reality and try to secure justice to those who have been discriminated on the basis of caste. This is an example that there are enlightened individuals both in our judiciary and in our society who would want to who are hell bent on making an who are motivating us to make an effort to bring about the necessary reform in our both educational institution, in the daily functioning of the economy. And he said this with respect to the uh, stigmatization and assaults on the basis of grounds of caste. He says that caste defines their identity and every day of their lives, as they're reminded of the castes by the perpetrators of those who practice discrimination on the ground of caste, he said. He further said that it is not to make a casteless society, but to empower those who have been subjected to centuries of discrimination. He said that there is a need of our to give them an equal opportunity, but I do not think this is right exactly only through reservation. A lot needs to be done within the educational curriculum as well. For example, ability for access to resources, being able to equally participate in the classroom and outside, both inside and outside the classroom, and experiencing stigmatization in the campus of bullying, to name a few.
Ma'am, since we're on the topic of
Furthermore,
yes, ma'am, can I proceed
pardon?
with my quest? Can I proceed with my
Yeah,
question?
yeah, yeah.
Yes, ma'am. Since we're on the topic of reservation, uh, like there are certain concerns raised that the benefit of reservation has been overtaken and it's causing more harm than good at this point by certain group of people. What is your opinion on that at this point? It's been more than 65 years, I believe, of independence, and then even now, the reservation system still exists. So, do you think it's high time to move it out, or should it still be in place?
No, it is, as we see, our social life politics are completely intertwined with the legislative enactments and the policy formulated by the government. So it is really hard to completely do away with the reservations as such, but we can slowly and eventually bring down the percentage of reservation that we provide in public jobs, in education, with respect to social welfare benefits. then we could see somewhat difference. But at the same time, we should have an adjustment process in place as well. When we are removing the reservation granted to a certain section of our protected class, we should enable economic economic awareness, and their capacity and willingness to undertake the full development of the personality to participate in the economy of a state, which is a part of Article 21 of the Indian Constitution. Their life to their right to life, dignity, and health is an essential fundamental is an essential part and parcel of a constitution. So we what policies we have in place, they should emphasize on educational attainment. If we improve the educational attainment level, uh, subsidizing the education and providing more apprentice training opportunities for this protected section of a class, then we can slowly do away with the reservation. Not completely, we cannot do that step all alone in isolation, I think, because we would see witness um, intense amount of criticism of such a move, or see conflict between certain sections in in our society, which would disturb the public peace and order, or which would create a disruption in the harmony of a society. So I would say that has to be backed up by a adjustment process, I think.
Thank you, ma'am.
As yeah, yeah. And one more point I would like to emphasize: it is stated, it has been the champions of the LGBT right cut to. She has also said that they ask that the differences are to be ameliorated by the inclusion under this one statute. These sections of society, they just want to be included in this one statute. If we're talking that there should be no discrimination under Article 15, why this gender has not been interpreted broadly till now to include LGBT? Why there is no evolution of concept of the understanding of what is a sex or a gender? We have to be very, very uniform in evolving a jurisprudence of constitutional identity of an individual. Then only I think we can go for legislative reform. Not legislative reform, societal reform. If we can give them a uniform interpretation, an evolving one, which leaves a room for constant change, we could see that we could then witness the change in the understanding and mindset of the citizens of a country. They only move around with the regulation through police force, the police exercise of powers by the state. It's quite evident. So I think that would make a quite a lot of a difference then.
Yes, ma'am. Another point I would like to raise is that since we're discussing the LGBTQ rights right now, the hot topic obviously in the currently is about the same-sex marriage. Don't you think bringing a new legislation like this, such as same-sex marriage, will affect other laws which are in place, such as the Hindu Marriage Act or even the Special Marriages Act? Because according to these provisions, a marriage is a ceremony held between a man and a woman. So any change that comes in this country will obviously have its complications. Do you think that itself is a reason to why we should not make a change such as this? Because even when we went to the topic of transgender, the amount of legal complexities it's faced, I think it's going to be even more at this point. So what is your stand on it?
I think just if we amend these legislation such as the Hindu Marriage Act or Special Marriage Act, but it's suggested that the if this legislation in regards to LGBTQ is brought in, they could register the marriage under Special Marriage Act. There will be no problem. For example, I can give you an example. uh, this equal that would not I think it would be permissible because recently Supreme Court has turned 30 days notice under Special Marriage Act as patriarchal, which it's ongoing in the present case. So I think Supreme Court will be more open to a broad interpretation to provide that the LGBT couples can register their marriage under this act. However, this has been criticized, or uh, the council for the government has stated that the legislating on or taking policy stance on LGBTQ right is solely under the parliament's ambit. But I think if judiciary can intervene when there is a loophole in our law, or there is to be a correct interpretation to be provided to leave no room for ambiguity, to remove any confusion when we are interpreting a provision of statutes. The role of the Supreme Court, or the role of the court, comes into play there and then. And for example, from this present proceedings, I can say that Chandrachud has also stated on the contention against homosexual couples raising children. He says that there are no absolutes, as he questioned the impact of domestic violence on children of a heterosexual couple. There is only physical characteristics which are distinguishing the different kinds of gender, but this should not just limit the understanding of what a protected class or criteria should be like. And and he's further stated that this the notice that is to be given under Special Marriage Act is very patriarchal and is invasion onto society. Justice Bhatt in the same proceedings has said that the notice system was only based on patriarchy, and these laws were made when women did not have an agency. CGI Chandrachud has noted that this is like laying them open for invasion by the society, including the superintendent of police, the district magistrates. He's also further said that if the intention behind the notice is to prevent marriages that could end up being unlawful, then the method is not proportional. No. Furthermore, the counsel for the petitioner, Dr. Abhishek Manu Singh, has also said that the personal laws in the country do not discriminate, unlike the Special Marriage Act of 1954. They have criticized it while arguing against the mandatory 30-day notice period in it. He asserted this is an invitation to disaster and violence. Further, on the contention against homosexual couples, the Chandrachud in the same proceedings, he said he takes an example of domestic violence. For example, if there is a heterosexual couple and the child seeks domestic violence, will he grow up in a normal atmosphere? If his alcoholic father comes home and thrashes his mother every night, there are no absolute. There should no be any strict boundary within how we conceive a sex or a gender. And also further, he said that on the notion of negative psychological impact which would be caused to children raised by queer couples, the Chief Justice of India further noted that argument was belied by the fact that the law as it stands today already allows single individuals to adopt. Incidentally, with respect to adoption, he further said, Chandrachud further said that even if a couple is in a gay relationship or a lesbian relationship, one of them can still adopt. So the argument that this will create a psychological impact on the child is belied by the fact that today, as the law stands, it's open for them to adopt. It's just that the child loses the benefits of parenthood of both the parents. CGI observed as reported. The petitioner in the same case with respect to discrimination further stated that if straight couples who cannot procreate are allowed to marry, why not the LGBT, lesbian, gay, transgender, or queer? Why they are not? Why aren't they allowed to marry? With respect to it, senior advocate KV Vishwanathan argued, Center says that by our very nature we cannot procreate. Is procreation a valid defense from keeping us from effects of marriage? None of the marriage statutes prescribe any upper limit for marriage. Women beyond 45 who are unfit for pregnancy are allowed to marry. Heterosexual couples who cannot have children are allowed to marry. But why not the LGBTQ? Why there is a unjustified or unreasonable discrimination between the equal, unequal treatment between the equal? Furthermore, the petitioner also argued that if the right to marry a person of choice is guaranteed under Article 21 with respect to protection of life and personal liberty, he said that I should not have to give notice to exercise my fundamental right, as the Special Marriage Act demands. Furthermore, he is also in the he states that there was no data from the government to back up its contention that same-sex marriage was an urban elitist idea. Some of the arguments made by by the counsel for the respondent is quite irrational. For example, using LGBT as urban elitist concept reflects the understanding of the policy normative, the norms that they imbibe in their policies, which is not in compliance with the constitution. They this is one of the examples, and now I'll give you an understanding of the same concept, the understanding of the government on this issue.
Ma'am, we do have a question raised. Do you wish to address the question?
Sure, sure, sure.
Should I read it out?
Yes, please do.
So Sujit asks why people interested in same-sex marriage cannot keep it in their private rooms. Why do they seek social validation and why do they want to register it? And I think this question contains both a social perspective and a legal perspective. So I hope you could clear his doubt accordingly.
It is because of they, um, in our society there's still stigmatization of couples living out of the wedlock, especially so if they are from the other sex or gender on are not complying with the norms of the society. So to validify those uh, archaic notions of the society, they want, or they just want to have that. um they want to grow that bond through a legally recognized uh, institution of marriage. And especially they face few of the drawbacks if they're not able to register the marriage. Give me a moment. Because it's needed, because it is surveyed in 2009 to 10 that of 427 LGBT people, 85% said that this change is needed. It's a high priority because segregation is not equality. Even though the legal rights and responsibilities of civil partnership in marriage are almost identical, the two are not perceived as of equal status and value. For example, civil partnership is seen as a legal contract, while marriage is seen by many as the gold standard for celebrating the joy of love and commitment. Marriage is very widely understood for its symbolism and its personal, community, and in some cases religious significance. Very few people propose to the partner by asking, "Will you civil partner me?" Civil partnership just does not have the same meaning if you can get that understanding of it. Civil partnership was invented specifically to deny same-sex couples to access marriage, and is seen by many same-sex couples as second-class citizens. Put in a different manner, equality means making the same choice available to all. If mixed race couples were denied the opportunity to marry and instead offered civil partnership with the same legal effects, that would readily be seen as unacceptable racist discrimination. The ban on the same sex couples marrying is equally unacceptable. However, it is also very important to understand that the introduction of same sex marriage would not eliminate this discrimination against same sex married couples, but it would remove the problem of ignorance and remove one of the excuses for the prejudice. Moreover, the segregated status of civil partnership, including the separate terminology in itself, defines same sex couple as the other and thereby promotes stigmatization, prejudice, and discrimination against LGBT people. I hope I'm able to satisfy your question with the answer. And this bias is
That's
also in the form of homophobia, biphobia, transphobia, and forms including bullying and hate crime. So that is why to remove the otherness, we need to have a marriage law applicable to them.
Ahmed, do you have a question? Ahmed, you're on mute.
Yes, I have a question. Thank you very much for the wonderful presentation. My question is straightforward and legal, and of course, it can also be academic in nature. I have like two or three questions. My first question is that, like, in your own opinion, do you really believe that um, people like LGBTQ, I mean, the membership and all the people, would actually claim right to freedom of discrimination, like looking at the literal expression of the law? Because if you want to claim discrimination, basically, of course, you are going to claim equality before the law. You claim maybe freedom from anything or anything on the basis of race, ethnicity, religion, or sex. But basically, they usually go through these. They usually go through sex. First, I want to say that, in my own opinion, the fact that there is a prohibition for LGBTQ couples not to marry, or there should be no marriage of same, like there should be no same-sex marriage. Does that means discrimination against sex? We're supposed to understand what sex means. You should not marry. You should not
Yes.
marry is different from I'm discriminating on the basis of sex or not. There are two things involved, because there has been, I think I've read some articles on this explanation on whether actually LGBTQ can actually claim right to freedom from discrimination, or basically whether they can claim either right to privacy. Of course, I would rather even I will not talk had it been they are basing their claim on right to privacy. But actually, okay, let us even assume that they are actually basing it on discrimination, of which I do not agree, because I believe discrimination, LGBTQ should not be able to bring claim based on discrimination, because even looking at the express, the way it is written, it is subject to different interpretation depending on the way you interpret it. I want to say that discrimination also should not be absolute. Of course, it is not even absolute. Even looking at the ICPCR and the ICSCR, it has exceptions, no doubt. Like, it has exceptions, of which it gives room to special provisions, and let me say, reasonable accommodation. Because even there are situations where even the children, even a mere child, is not allowed to take a particular drink in a particular country. Should that also be should not take a particular drink or a particular or should not do a particular thing of which the law also allow through the CRC? It may be based on morality, of which even the law also recognizes maybe through exceptions. Even the right to privacy, let us even assume that they're also coming from right to privacy. We also know that right to privacy is also not absolute, because of course there is an exception to it. I will say that of course nothing shall also stop this, shall also make any law to be illegal in a reasonable, justifiable society. They will put all this reasonable way. So basically, what I'm just trying to say is that, will you, in your opinion, looking at the both general rule and exceptions, still say that LGBTQ should be able to claim right to freedom from discrimination, or will you say that there is no particular law that is supporting same sex yet, but what we have is like expansion of provisions? Of course, and again, I want to also state this, which is very clearly that reasonability is subjective. What is reasonable in the United States may not be reasonable in India. What is reasonable in Nigeria may not be reasonable. Probably it may not be reasonable in Malaysia. So what I'm trying to say is that, of course, based on the adage that when you go to Romans, you have to do when you go to Rome, you have to do like the way Romans do. Of course, of which, of course, is also making reference to the morality of the respective morality in each community. That is, all of us, we have our respective moral consciousness. We can choose, if the Western country should choose that, okay, let LGBTQ should be allowed based on right to privacy and right to discrimination, without making reference to the exceptions, which also which also allow like exception, which allow some situation where the government could choose not to allow it based on just based on some reasonable justification. So, and since I have already said that if some countries are also taking it in, they are just taking it in based on their own moral consciousness. That is what they believe in that country, because they believe it is moral in that country. But in another country, they do not believe it is moral. Could you blame a government on that? And of course, I want you to look at it in both social and legal perspective, looking at both general rules and exceptions to each right, because I believe not all rights are absolute. Some rights are definitely not absolute, and discrimination is one of it. So the second question is that, when I don't know, most times whenever I hear about right to freedom of discrimination, basically it's always talking about women. So really, it's an interesting topic actually. The question is that, why there can be a discrimination against men? Why is it that whenever we're talking about discrimination, it goes to only women? And even looking at, let me say, discrimination itself is a first generation right, which is to all kinds of rights. Common to socio-economic right. It's also available in civil and political right. That is, it is available in both rights. So in that sense, looking at the way the first part of ICPCR and the ICESR is written, it states that those rights that are contained in the ICESR, that is personal liberty, right to life, and others, in both these things, should also be applied indiscriminately. Like, it should be applied without discrimination. That is complementarity part of right to freedom of discrimination. So my question is simple. Like, you can see that after making that law, another article or another convention came in, that is CEDAW, Convention against on all elimination, whatever, that is all discrimination, all elimination of all discrimination against women. I want to ask you that even the convention itself, the word CEDAW, will you term that word as discriminatory? When you want to make CEDAW, you were only making reference to women, of which there are also men involved. So are you not saying that the only discrimination we have is only against women? We don't have men that are also involved in this situation. And of course, you also make they have already stated earlier that if the states want to apply the rights, all the rights that are contained in the ICPCR and the ICESR, if they want to apply both all these rights that are contained, they should apply it without any discrimination. So subsequently, the states now chose to bring about on their in their own volition, they bring about a new convention of CEDAW, which is not only discriminating against men, but it is totally wiping out men in its name. So I want to hear your opinion about, because I find that topic very interesting. It's a topic that I discussed yesterday. Thank you very much.
Thank you for the questions raised. So I would want to give a brief and concise to your questions raised. Um, what is reasonable to you, as you suggested, varies from one person to individual to individual, from country to country, continent to continent, and from to culture. But a basic understanding is that reasonable is anyone in a particular situation will act in a rational mindset, which does not uh, shock the society or shock the mindset of the society as such. Should be very proportionate. So when we are depriving an individual or class of sections from their rights, from discriminating them or preventing them from exercise their rights to, for example, the right to marry, right to cohabit, or access rights to abortion, it would be very unreasonable from that perspective. Because as such, this has been upheld in various jurisdictions, such as in the Republic of Ireland, in the United States, um, in countries like Denmark, Netherlands. Netherlands was one of the first countries to recognize and emphasize on gender equality, inclusive of LGBTQ right. So it is like if so many jurisdictions have expanded the concept of sex and gender, so it cannot merely be unreasonable from that perspective. And I think if you apply the constructive theory of international relations, constructivism means evolving a concept according to changing circumstances and conditions in our society. So, if a law is enacted in 1957, it cannot remain stagnant. If we see economic and socio-cultural changes in our society, it should take consideration, expand either expand the scope of the law, or either narrow down, or that particular law should be completely removed, I think. And as when it comes to gender discrimination, it can be both against women and men. I totally agree with that. But if you see the statistics in India, there is more and more, there is more violation, or not violation, when you say infringement on very basic rights, even of the women and other genders as such in our country. If I had the statistics with me, I would have given you, but uh, there is more instances or the chances of domestic violence, dowry, infanticide, um, uh, lesser participation of women in the economy, to name a few. So if you see, there is like if one gender is given higher stature or position in a society, there's bound to be discrimination towards the opposite gender. So the circumstances from an Indian perspective is different. If you see, there are other prejudices also in with respect to wage gap. Is one, to name a few. But I think it should also be addressed. Um, the instances against or arbitrary or unacceptable treatment of men in society, be it in workplace or from a social perspective.
All right. Thank you very much.
One more thing I would want to elaborate on. I have to give you an argument from the government's side, and it would be for you to decide what is the right position here. I mean, everyone has the mind of their own to formulate and express the choices to what they feel. So I will give you a few arguments of the government in this present case. They have said that the LGBT is a seminal importance, and it's the courts cannot deal with it. This is a very narrow argument that any government could give in a court, because it's like having complete separation of powers would eliminate the idea of distributive justice. It would prevent uh, the principles of rule of law from being implemented. This is a very flawed argument given by the government in this right now. And one more thing, and furthermore, the government has also said that gay marriage is not compatible with the concept of an Indian family unit, which is quite prejudiced. If we see, we Indian culture boasts of concept of Kama Sutra, which depicted uh, cultural practices of the LGBTs and the Enungs. To name, this is one of the example. How could they give such a flawed normative concept as their argument here? One more thing. They further said that it's the notion of marriage itself is necessarily and inevitably presupposes a union between two persons of the opposite sex. This definition is socially, culturally, and legally ingrained into the very idea and concept of marriage, and ought not to be disturbed or diluted by judicial interpretation, the law ministry had said. Uh, this is a very flawed understanding of sex, which is very archaic, arbitrary, uh, does not take into consideration or persuasive precedents of other jurisdictions such as Republic of Ireland, Netherlands, Denmark, where these are few countries in which LGBTQ rights have been completely legalized, and there's no dysfunction over there. There are few challenges in every country, but they have been accepted very well over there. So why not in India?
Okay, I guess we have a question here. Say,
And we have
man,
a question.
according to your opinion, what is marriage and how do you interpret it? Can you hear me, Miss
It's
Bali?
a union. It's a social union. It's union of two minds and souls to get together to form and to be recognized legally in the society, and they should have rights of both the parents if they want to, if they want to start the family of their own, if they want to beget a child, if they want to adopt, if they want to um, uh, carry out surrogacy, to they should have equal rights as in of as heterosexual couples have. But the definition of marriage would take, it's entirely total social concept, it will take a lot of time to completely define. But I would say that it's a legally and socially sanctioned union that is regulated both by laws, rules, beliefs, customs, and attitudes, which I believe should change over the period of time. For example, the Netherlands, it has been recognized over there, and the nature of marriage has completely changed, with especially with respect to importance which is given to procreation, and with the ease of divorce. Some countries have also extended benefits and obligations to same-sex couples by means of a registered partnership. But it marriage, what is important is that it confers a legitimate status on the offspring, and which it's for the offspring, and which entitles him or her to the various privileges set down by the traditions of that community, including the right of inheritance. uh, uh, historically it has been a very flawed concept. It has been a very narrow archaic concept comprising of what is an endogamy, what is exogamy, choosing a partner according to few decided characteristic. But I think with countries like United States, Netherlands and Ireland implementing a liberal policy and England implementing a liberal policy, the understanding of customs and tradition should also evolve to reflect the evolutionary characteristics of constitutions. And the expanded definition, finally, I would say that it formalizes the decision of two people to live as married couple, including the to should be accompanied by accompanying social festivities. It's about giving them the pledge that they will remain devoted to each other in the manner of a husband and wife without legal sanction. And this decision, that this definition has been expanded in the case of Obergefell, so United States Supreme Court's decision in Obergefell, which changes nothing. And United States has changed the applications to the government's definition of marriage. So there's some positive development in the United States. In the United States, civil marriages may also be part of religious ceremonies and held at the same times, but they're distinct and separate. But they're amalgamating. They should they should they're not amalgamating, but both these processes should take simultaneously and concurrently. Thus expanding the social effectiveness of how an LGBTQ's rights should be exercised. So I think it has to be changed from judicial interpretation. The customs are somewhat archaic in nature, which have been formed over practice and obligation and see sense of feelingness over the generations. But it's time that we follow something which is scientifically proven. I hope my answer satisfies your question.
Yes, Miss Bali.
Okay.
Are we taking more questions or do you want to end the session here?
So I would want if you want more questions, or if you would want to point out your own understanding of how this concept has evolved, I would be happy to witness it. If anything that you want to add,
Yes,
because it's
ma'am,
an
definitely.
open-ended conversation. It's not just one-sided.
Yes, ma'am. I would encourage other participants if me and Ahmed have been constantly giving us our opinions. I would encourage if anyone else is interested in they're giving their point of view, I would cordially invite you right now. Or else I will continue with my part.
Yeah, please do.
Yes, ma'am. So obviously, this discussion has really opened up the perspective for a lot of people, I think. And I think the right standpoint, in my opinion, is that the rights of LGBTQ people should be granted. They should be recognized as, the same-sex marriage should be recognized at this point. As, anyways, I know the reasoning provided by the center is mostly based on social stigmas and all that, and the actual problem comes only when we get into the legal complexities. But if we consider the greater good, where it's now right now same-sex marriage people who are in same-sex relationships, they can't register their marriages. Now this is one of the main point raised by the famous lawyer Menaka Guruswamy, that that these couples can't register each of themselves for life insurance or anything of such sort. Now that brings a great complexities for these couples in terms of their future. Now we don't get to think those part of point. The people what usually they consider is that yes, the section 377 has been legalized, so why can't they be satisfied with that? No, that's not the whole point of it. The whole point of it is that they want to consider themselves as a married couple so that they can avail the benefits of marriages, which are pretty much there in all aspects of the society. And I think uh, one second, ma'am. Yes, and I think as a reason, I think I would favor in favor of legalizing same-sex marriage, and also in her words itself, in the words of Menaka Guruswamy, the rights of minors should not be dictated by a majority group, and that's what I believe in.
Well, that's perspective. That's a brilliant, like your perspective. You have an expanded notion of how what a minority constitutes and how their rights should be perceived in an understanding of the recent controversies. It is a brilliant perspective. But if anyone still wants to continue the discussion, you can get my I can give in my email ID here, and you can feel free to conduct more discussions like this. It has been a fruitful discussion indeed for me after a period of time that I'm engaging in a panel discussion like this, and constitutional law not being a major specialization for me, but I'm very keen and passionate about the same. It's just giving me more perspective and confidence to engage in talks like this. I give my contact details on the chat. Where is the chat button here? Okay. Feel free to add me on LinkedIn as well. We'll continue discussing about this topic more, because a lot needs to be still discussed till we actually completely understand the entire picture of what is going to happen in the recent judgment. I'm awaiting the final judgment and see. It will make a lot of difference, not just for the gender and sex rights, but only for gender understanding of concept of equality, and more force against right against force for right against prohibition against discrimination. It is very essential that we as law students and as professionals keenly and basically understand the basic roots and elements of what is discrimination. So next seminar when we conduct, we'll get into more details of the gist and understanding of the concept, I think, instead of just going through the constitutional provisions and just and the precedents. If anyone else is willing to conduct this seminar with respect to it, I'll be open to that. And thank you very much for giving me this opportunity to express my thoughts and opinions on the topic of prohibition against discrimination and right to equality.
Thank you very much, Ma, for that wonderful presentation. Also,
Thank you.
we will be taking some questions. I don't know if there's anybody that is interested. Please, do you have anybody
Uh,
with a question? You can raise your hand.
Ahmed, I would suggest we end the session because we have to it's time to. So I think there's no more question here, and we'll end the session. You can give your vote of thanks.
Okay. So I don't think we have any question here.
Ahmed, do you want me to, are you going to give an ending to this?
Should we end the session?
Yes. Do you have a vote of thanks prepared?
It's okay. There's no need to thank me. I mean,
Ahmed,
I should.
no, ma'am. We definitely have to thank you on behalf of LRA for giving a wonderful session.
Oh,
I was
thank you very much.
yes, ma'am.
Sorry, I didn't know that. I knew that. Thank you. It is my distinct pleasure. Uh, So in fact, it was very interesting. It was a very interesting one. Like I could not
I sh-
actually believe that you will be able to trash the whole issue. It was an enlightening and thought provoking session, and it has been very exploring. And also today, maybe I should just give a summary of what you said. Miss Bali embarked on the journey to examine the complexities that is surrounding the essential aspect of human right, that is right to freedom of discrimination. And she expertly guided us through the nuances and the challenges and possibilities that lied ahead, particularly in the aspect of the LGBTQ. In her profound insight, Ms. Bali reminded us that discrimination knows no boundaries. It permeates societies, according to the way she answered me in institution, and even subconscious mind. So she emphasized the urgency of acknowledging our biases and challenging the status quo to foster an inconclusive world that celebrates diversity. Her words were really powerful, and it was some kind of reminder that each of us holds this key dismantling, like we still have this, this grudge against LGBTQ. But basically throughout the session we were inspired by the resilience and determination demonstrated by some of the lawyers and advocates that have fought for discrimination, and we learned that the progress is not inevitable, but rather the result of countless individuals and communities coming together to demand change, of course, and refusing to accept anything that is less than true equality. So, as we conclude this remarkable gathering, let us carry the wisdom and insight we have gained today into our daily lives. Let us be the catalyst, of change, engaging in open conversation, challenging discriminatory practices, and also we can also advocate for a world where everyone can live free from prejudice. So remember, the right to freedom from discrimination is not a mere concept; it is a call to action. Am I right, Ms. Bali? It is a
yes,
call.
definitely,
It is urging us to stand up against injustice and create a better future for generations to come. Together, we can build, of course, a world where everyone is celebrated for their qualities, where diversity, of course, will be embraced, and where discrimination will have no place. Thank you, Miss Bali, for your enlightening discourse, and thank you for being for being an active participant, of course, and in this crucial conversation. So let us carry the spirit of the session forward and continue striving for a world where the right to freedom from discrimination is not just a lofty ideal, but a living reality. Goodbye, and
bye
may
bye,
our collective efforts to transform the world into a beacon of equality, respect, and harmony. Thank you very much. Really appreciate you, Miss Bad.
bye bye.
Thank you, ma'am.